夠啦，應該係嘛？應該夠啦。1、2、3、4、5、6、7、8個啦嘛，係嘛 ？OK。首先歡迎
Welcome members for attending the panel on administration of justice and legal services. First of all, Happy New Year. We have a quorum. I call the meeting to order. First of all, information paper issued since the last meeting. CB bracket 4387/14-15 Judiciary Administration's paper entitled Proposed Legislative Amendments Relating to the Notice of Abandonment in the Schedule to the Criminal Appeal Rules, Cap 221 Subleg A. And I'd like to draw members' attention that items for discussion at the next meeting are paper numbered CB bracket 4367/14-15 bracket 01. And there's also a letter sent by Mr. Tang Ka-piu dated the 15th of January this year, asking to discuss the assignments of lawyers to legally aided persons by the Legal Aid Department. It's paper number CB bracket 4378/14-15 bracket 01. And there's also a list of follow-up actions. Paper number CB bracket 4367/14-15 bracket 02. In Mr. Tang's letter, he asked to discuss about the assignments of lawyers and whether it will lead to abuse of legal aid. You can read his letter, but he told us that he cannot attend this meeting. He asked me to mention this. There is another letter from Mr. Leung Kwok Hong. It's dated the 23rd of January. It's tabled in front of you. It's also in relation to legal aid services. We're asked to discuss with the administration about the need of legal aid and how it will ensure that those without the means will still have access to justice. If you look at the list of outstanding items for discussion, I propose that in March we should discuss about the criteria for approving legal aid applications. Mr. Leung and Mr. Tang asked to discuss matters related to legal aid. We can discuss it in the meeting because this item is about criteria for approving legal aid applications, assignment of lawyers, etc. Do you agree? Ms. Emily Lau. I don't have much to say, but you draw our attention to the papers table. There is also one from Association Concerning Sexual Violence Against Women. They understand that it's only a discussion between members and the administration, but they would like to have a meeting as soon as possible, inviting interested organizations to come to express their views. We will discuss an item in item 4 that is related to this, and I think we can defer a further discussion till we reach that stage. There is also another request is from the FTU. They sent us a letter on the 19th of January. They asked this panel to have a discussion about a wage in default. Well, apart from the ATV, there are about 5,000 or so similar cases. The prosecution division of the DOJ is said to have not complied with their performance pledge to provide legal guidance to the relevant law enforcement agency within 14 days, and they have not abided by the prosecution code. And I would like to say to you that, well, in relation to this item, we have also CC'd to the Judiciary and also the Manpower Panel. Isn't this more appropriate to be discussed by the Manpower Panel? If they're interested, then this item will be discussed by them because it seems to be a better platform. But the letter was sent to us. Oh, it's actually the letter from the Hong Kong and Kowloon Trades Union Council. And the administration proposes to discuss two matters on the meeting on the 23rd of February. One is the draft called Procedural Rules for the Competition Tribunal. The other one is the proposed amendment of the Legal Aid Assessment of Resources and Contributions Regulations and adjustments of the financial eligibility limits of the ordinary and supplementary legal aid schemes. We understand that these two items are related to subsidiary legislations. Now they will have to come to this panel for discussion. In relation to the draft called Procedural Rules for the Competition Tribunal, it may need a bit more time. Do we give them more time for discussion, or is it the case that members won't have much to say and we can add one more item to the agenda? I would like to hear your views. Do you think that we need more time for item 1 in the next meeting? Mr. Tam Yu-jung. I can't say whether there will be a lot of discussion in this panel. But what about the Economic Development Panel? Will their members be more concerned? Because it's also related to them. It's about the competition ordinance, and it may also affect them. So you are saying that we should invite other members? Yes. Do any other members think that we need more time for this item? We have a long list of outstanding items. Maybe the administration thinks that we only have time for 2 items in the next meeting. I would like to know how interested you are on this, because we have to think about allotting how much time to allot to each item. I incline to give more time to the first item. People from the legal sector asked to have more time. Let's do it this way then. You may need to do some preparations. Well, the competition tribunal is established under the competition ordinance. Is a superior court of record with primary jurisdictions to hear and adjudicate on enforcement cases brought by the Competition Commission, follow on private actions, alleged contravention of a conduct rule as a defense raised in proceedings before the court of first instance, as well as reviews of certain determinations. The judiciary is preparing the procedural and other related rules. Mr. Paul Jay. Sorry, I was at another panel. I don't know whether there was any discussion about making use of the start of the new year, especially after the Occupy movement. The impact on society. As you know that the Chief Justice, the Chairman of the Bar Association and the Secretary for Justice in the opening of the legal year expressed their views. And there are lots of concerns from society. This is the panel about justice and legal services. We should seize the opportunity to have further discussions and don't let it stop at the opening of the legal year. We should discuss about what is rule of law and whether Hong Kong's rule of law is progressing, deteriorating, or what. Any other members who would like to say anything? Yes, this is also close to the heart to the general public. Before you entered, we talk about two discussion items, and they are related to subsidiary legislations. We'll see if we can add it to the agenda. Or would you like to have an earlier discussion? This is still a hot topic. If we have an early discussion, I'm sure it will be welcomed by the public. Perhaps we can do a special meeting. Mr. Zhe, we will discuss the policy address. And one of the subtitles of the policy address is uphold the rule of law. So maybe we need to follow this up, and we will find a time slot to follow this up, because it's of public concern and the public are interested in a discussion. Let's do it this way. I'm sure this will be touched on in our later discussions.
Next. At the next meeting, well, actually after the last meeting, the chairman said we are going to discuss also legal aid. Some members have spoken to me about this. Now I'm still on the next meeting to be held on the 23rd of February. I'd like to point out to members that actually it is a Monday and the 5th day of the Chinese New Year. Some members have asked whether we could advance or postpone the meeting. I have done my best with the clerk, and we have found only two other time slots. One is the 9th of February, a Monday at 8:30 to 10:30, but it would clash with the transport panel and also the District Cooling Services Bills Committee. And another possibility is the 16th of February, also a Monday, from 2:30 p.m. to 4:30 p.m. Mr. Tam Yu-chung is here because that is also the slot for the Constitutional Affairs panel, and 19 of our members also are members of the CAP. I don't know whether you'd like to shuttle between meetings, because these are the two slots that we have been able to identify. We have done so in response to the request of 1 to 2 members who may still be out of town. So members, would you like to maintain our next meeting date as the 23rd of February, which is the 5th day of the Chinese New Year? What do you think? Or would you like to explore another slot which might clash with the CA panel. That may be difficult. So what do you think, Tam Yu-chung? In fact, I am also afraid not all members can come back in time for the CA panel, but then the budget will be announced 2 days after that. Theoretically, people should be back to Hong Kong, but they may be going to the districts to wish the Kaifongs or residents a happy Chinese New Year. So I think it's to play safe, you should postpone the meeting. Okay, other members. The 9th of February is a Monday, and it will be 8:30. But it clashes with the Transport Panel and the District Cooling Services Bills Committee. Do you think we should advance the meeting, members? Albert? You are fine, either day. You think it's okay if we clash with the CAP because you are happy to shuttle between meetings? Mr. Tam may not be able to come because he is the chairman of the CAP, but the other 18 members can be here. Members can have their presence recorded. Okay, well, let you know. So probably it will be the 16th. 16th of February at 2:30 in the afternoon, but it clashes with the CAP. Miss Emily Lau, what about 4:30? No venues? Well, too bad. Other members, any comments? Mr. Leung Kwok-hung, you just came in. We are now talking about whether we should advance the meeting of next month by 1 week. We should be able to convene the meeting, but we clash with another meeting. Okay, I've heard you. We'll issue the notice. I will try with the clerk again to see whether we can have the meeting at 4:30. Right, I have heard you. Now we go into the discussion items. According to Rules of Procedure, Rule 83A, if members have any direct or indirect pecuniary interests related to items for discussion at this meeting, please declare and disclose the nature of such interests before taking part in the discussions. Okay, we'll now invite the administration and other representatives to come into the meeting room. Item 3, briefing on the Chief Executive's 2015 policy address. We have 2 papers, CB bracket 4, 367 bracket 03. This is from the DOJ, and from the HAD, CB bracket 4, 367 bracket 04. I'd like to welcome representatives of the DOJ and also the HAB. The papers provided by the DOJ and the HAB serve to brief us on the relevant policies in the policy address. First of all, I'd like to invite Mr. Rimsky-Yuen, Secretary for Justice, and also Ms. Florence Hui, Undersecretary for Home Affairs, to take us through the papers, and then I will invite other representatives to speak up if they have a comment to make. First of all, Mr. Yuen. Chairman and members, since the DOJ Since the DOJ has already provided a very detailed paper describing the policy initiatives of the department in 2015, I will just go through the gist of our work in 2015. We will maintain the rule of law and also try to uphold Hong Kong's status as the center for mediation and dispute resolution in Asia. Now, that would be the main thrust of our work in 2015. This is what we are going to do in the various areas of work. First of all, promoting Hong Kong as the Asian Center for Resolution and Dispute Arrangement. At the beginning of the month, the PRC government and also Hong Kong have already signed the host country agreement so that we can have such dispute resolution done in Hong Kong, and so that we can attract more people to come and to choose Hong Kong as the place for arbitration. We will continue to do this because we would like to attract more international investment arbitration to Hong Kong. And also we would go for mediation first to encourage SMEs and other specific sectors, including intellectual property and also medical services, etc., to choose Hong Kong as the center of arbitration. We will, as fast as possible, consider whether to introduce an apology legislation in Hong Kong. In November, the China Maritime Arbitration Commission set up office in Hong Kong. We will continue to take measures in order to make it easier for legal and dispute resolution institutions to set up presence in Hong Kong. In this connection, we will take measures to provide such institutions with certain office space in the west wing of the former central government offices and the former French mission building upon the relocation of the Court of Final Appeal. Number 4, to continue to work in conjunction with the Hong Kong Trade Development Council on the development of arbitration in Hong Kong and the challenges and opportunities faced by Hong Kong as a center for international arbitration in the Asia-Pacific region. And number 5, enhancing the promotion of legal and dispute resolution services of Hong Kong among emerging economies in the Asia-Pacific region. We have set up the Advisory Committee on Promotion of Arbitration last year. They will provide advice and help to the DOJ in this area. With regard to working with the mainland, we have 3 main measures. We will continue to work together with the mainland so that we can enhance legal cooperation in civil and commercial matters. And also, according to the Framework Agreement on Hong Kong-Guangdong Cooperation, and also according to CEPA, we can enhance the development of cooperation with Guangdong in legal services. And number 3, working with the mainland authorities and the legal profession, arbitration and mediation institutions in Hong Kong to facilitate the provision of legal and dispute resolution services in the mainland by Hong Kong professionals. With regard to the legal system, we will look at public prosecution and other areas. With regard to public prosecution, the Public Prosecution Division will continue to provide training to people within and outside the department, and also new lawyers in private practice who would like to be engaged by the department to do prosecution. And we will enhance cooperation in the region and also internationally. We'll continue to conduct different activities so the public will better understand the public prosecution system and the rule of law. In terms of the handling of cases, we expect that there will be a big bulk of the work coming from the Occupy movement. We'll work according to the prosecution policy and apply the relevant laws in order to tackle each case in a fair and just manner. In terms of law drafting, in the coming year, we'll continue to promote the database for Hong Kong laws with legal status. In 2015-16, we'll like to complete the first phase, and that is that it will be a system for internal use. And in parallel, we will provide in-service training to law drafters, and we will also enhance our liaison with local and overseas experts in order to enhance the quality of legal drafting. In terms of legal reform, we are going to take a few new measures, and we also have ongoing efforts. First of all, we will seek to implement the LRC's report on criteria for service assurers, and also the report on hearsay in criminal proceedings, and we will be consulting the public on these. And also at the end of last year, we will start to promote the third parties' rights, and also we will continue to support the class action and also sexual recognition working groups in order to consider the class action proposals. And also after the conclusion of the W case of High Court, we are going to make the relevant legal proposals. With regard to the work that I have detailed, I hope to have your support, and together with my colleagues of DOJ, I would be very happy to take questions. Thank you.
好，多謝袁國強司長。而家我哋請
Thank you. Now I'd like to ask Ms. Florence Hui to introduce the paper to us. Chairman, members, I will now take you through the paper on legal aid and legal services in the policy address. The provision of legal services is to ensure that those who have the grounds to seek legal action will not be deprived because of a lack of means, and the applicants will have to pass both the means and merits test. In recent years, with the support of the LegCo, the administration has already enhanced substantially the financial eligibility limits of the ordinary legal aid scheme and the supplementary legal aid scheme, and also the scope has been expanded. Even so, we are still asking the Legal Aid Services Council to conduct a further review on the scope of the SLAS with a view to making a new round of recommendations to the administration. The Council has already set up a working group, and they will be consulting the relevant stakeholders, including the two legal professional bodies.
In the first half of 2015, we will introduce legislative amendments in relation to the assessment of resources and contributions under the legal aid schemes. We will also introduce legislative amendments to further adjust the OLAS and SLAS to take into account changes in the consumer price C. And in March last year, the HAB formed a working group looking into the review of criminal legal aid fees. We have engaged the Hong Kong Bar Association, the Law Society of Hong Kong, as well as representatives of the DOJ. We have exchanged views. We will continue meetings to discuss this matter. Depending on the progress, we will introduce legislative amendments to implement the recommendations. In March 2013, the HAB launched a pilot scheme for providing free legal service. And so far we have assisted 1,096 cases and offering over 3,000 quick advice sessions. We will continue to monitor the operation of this pilot scheme to map the way forward. In order to encourage more members of the legal profession to volunteer to provide legal service, in 2011 and 12 we launched the recognition scheme for provision of pro bono legal services. So far, there are a lot of legal firms and legal professions who have been recognized. And we launched the second pro bono scheme between the 1st of October 2014 and the 30th of September 2015. There will be at least 25 hours of legal services provided within this period. And in order to enhance the governance and transparency of the Legal Aid Services Council, there is a working group on expansion of SLAS set up. And we will continue to monitor the operation of the council and to strengthen the governance of the Legal Aid Department by enhancing transparency. Thank you. Thank you, Ms. Hui. I will now ask members to ask questions. I read out the names of those who have indicated before we decide the allocation of time. Mr. Wong Kwok Hing, Dennis Kwok, Tam Yiu Chung, Ray Chan, Emily Lau, Paul Zhe, Albert Ho, Leung Kwok Hong, and myself. There are 9 members. I would like to give you 5 minutes. Answers, question and answers included. 1 round only. Mr. Wong Kwok Hing. Chairman, in relation to what this SJ said, that the prosecution division will have the majority of the work coming from prosecutions after the Occupy movement, which is illegal. So I have a question for the S4J. In relation to prosecutions of this illegal movement, it is to uphold Hong Kong's rule of law. Whether it's done right, whether it is done without with impartiality, is very important to our law. If you're too relaxed, if you do not enforce the law accordingly, in a way you encourage people to step it up at the next stage, because that is always possible. I have a question for the Secretary. There are lots of celebrities and people from the legal sector and even lawmakers in the illegal movement. Well, you want to canvass their votes because you want them to support your constitutional reform. Well, I'm talking about 20 pan-democrats or so. They took the lead to break the law. So I have a question for the Secretary. Would you be lax in your prosecution and enforcement? Another question is in relation to civil claims against the occupied trio. It first was initiated in the small claims because you don't need legal representatives. However, those people want to amalgamate the cases and have it sent to a higher level of court. Well, the members of the public are just ordinary citizens. They took legal experts and scholars of law to the court, but they themselves know very little about the law. Don't you think it's very unfair? Secretary. I thank Mr. Wong for his questions. In relation to the first part of his questions, we've always followed the prosecution's code in our work. There are 2 parts. First, whether there is a sufficient evidence to a higher chance of a conviction. And if there is sufficient evidence, whether prosecution is in line with public interest. The code is applied to all criminal cases. In relation to the possible criminal cases related to the Occupy movement, the same code will be applied. We fully understand what Mr. Wong said. If we do not act in accordance with the law and on the evidence and take action, it may send a wrong message to society that if you break the law, you may not have to shoulder the consequence. It will have a negative impact on our society. On the other hand, we have to act in accordance with the law and on evidence. Mr. Wong mentioned celebrities, people from the legal sector, and legislators. I can clearly say to you, I myself and the DPP also both said that when it comes to a decision to prosecute or not, the capacity of the person involved, whether it's a known person or not, whether it's from the legal sector or not, whether it's a lawmaker, they will be given the same treatment. Mr. Wong talked about lawmakers that the government would canvass for votes. That will not be a factor in our decision to prosecute or not. We do not consider anything that is outside the law and outside evidence. In relation to the second part of Mr. Wong's question, that is some civil claims as a result of the Occupy movement and some small claims tribunal cases, there is a possibility that they will be transferred to a higher court. The people involved may not have access to proper redress. Well, it depends on whether the parties involved are eligible for legal aid. And if they are eligible, then they will be given assistance. And in relation to civil claims, the DOJ is not involved because it's a monetary claim. Sorry, we have to stick to the time. You've overrun for 30 seconds. Mr. Dennis Kwok. Mr. Dennis Kwok. Do we have time for 2 rounds? Or there's only one? Let's see. Ask the questions first. My questions will be brief. First, in relation to legal aid. Previously, you mentioned about the portfolio of legal aid will be transferred from the HAB to DOJ. When will it be done? Is there a timetable? That's the first question. And in relation to development of arbitration, I see that it's highlighted in the policy address and is also mentioned by the Secretary. 2 questions. Apart from the PCA, Permanent Court of Arbitration, are there any other international arbitration organizations planning to come to Hong Kong? And there is in relation to the French mission building. If an international arbitration organization is moving to that building, how much money do you have planned to help to convert the building into an international arbitration center of an international standard? The third question is about criminal prosecution. Before Mr. Servos retired in August 2013, he was asked about the progress of the case against Donald Tsang. He said very soon, but we have not seen any progress at all. So can the DPP give us a reply? And about resources for the judiciary. However, Mr. Choi and those from the judiciary are not here, but I will save that question for later. But that is of concern to us because we are concerned about manpower and resources of the judiciary. Secretary, I will briefly answer Mr. Kwok's question. First, in relation to legal aid. The proposal then was to revert to the original system. That is, the portfolio of legal aid will be moved to under the DOJ and not the HAB. We are considering the general principle. The information I have is that there is no specific timetable. But it depends on the workload of the administration and resources deployment. Apart from PCA, In relation to arbitration, all I can say now is that there are other international organizations that are having discussions with us. Since the discussion is ongoing, we and the administration and other departments would like to not divulge any more information. And in relation to the ex-French foreign mission building, and letting it be used by some international organization, we are at the moment assessing the cost involved. I thank Mr. Kwok for his question. Hopefully, when we apply for funding approval, we will get your support. You know that this is a historic building. The relocation or renovation would be higher than other buildings. We are in the process of making assessment. Once we have the figure, we will revert to you. And what about the public prosecution? Well, about the ex-CE, I'll defer to the DPP. In relation to the investigation into the ex-chief executive, we are in close liaison with the ICAC. We are now studying the relevant law and evidence. I am not in a position to divulge the progress of the investigation. Let me use Kevin Servo's words very soon. But that was over 10 months ago. So investigation has completed. You are looking at the evidence and making preparations. Yes. Next, Mr. Tam Yu Chung. Just now, Mr. Wong Kwok King was concerned about prosecution against people involved in the occupation movement. The secretary said that he would be very careful and he would follow the prosecution code. My understanding is that, well, the ex-DPP, Mr. Kevin Servos, before his departure, he amended the code, especially when it comes to public order events, that chapter.
As a layman, I can see that there were also some comments from the community that the new code only emphasizes the protection of freedom in the basic law. But then when it comes to public prosecution, we should also uphold the other parts of the basic law. Therefore, we don't know how the DPP will really follow the spirit of the law when someone breaks the law. I have some worries. I don't know what the Secretary can say about that. Secretary, thank you, Mr. Tam, for that question. Mr. Tam, you are correct. We have a new prosecution code which is the subject of certain amendments with regard to offenses about public order. But overall speaking, we did not include new principles. Rather, we looked at case law coming from the CFA, and we have included the main points of the judgment on POE, and they have been listed in the prosecution code. It is not that we wanted to bring in a new way of working, but rather we'd like to list the relevant legal principles in the code so that public prosecutors would have an ease of reference. In fact, before the amendment, we have also used the same case law and the same legal principles. And Mr. Tam and other members, please rest assured that with regard to such case law or other literature, when we respect human rights and also basic rights of assembly and speech, these cases would represent a balance between public order and the freedom to express oneself. Like the case involving Yang Mei Wan. And in public order events, for example, offenses that may arise from the Occupy movement, the public prosecution section will always strike a balance. As I said, we will look at the law, evidence, and public interest. So on the one hand, we have to strike a balance, and on the other, we don't want to send the wrong message to the community that without a reasonable excuse, people do not have to take legal responsibility for breaking the law. We will be very cautious in tackling these cases. Can I ask something else? You said that you expect a lot of prosecution work. How can you complete your work within a short time, because the community would like you to work fast? Secretary, thank you, Mr. Tam, for the question. Frankly speaking, we have a big backlog of cases, and frankly speaking, this has constituted quite big pressure of work on the Public Prosecution Division, and we are deploying resources internally. We have now got a dedicated team of prosecutors to handle these cases, and other cases that do not have to do with public order might be farmed out to outside barristers. So we can have manpower enough to tackle such cases, because this will be in the interest of the public and also the defendants. Mr. Ray Chan. Thank you, Chairman. Well, I like to tell the Secretary this first. You cannot rush with prosecutions. You should not put pressure on your colleagues. I have known from the public that, in fact, the prosecution letter you sent them were put in the wrong envelope. In other words, the name on the letter and the name on the envelope are different. So if you pressurize your colleagues too much, they make mistakes. But I'm not a member of the panel, and I'd like to thank the chairman for allowing me to be here. I'm very concerned about sexual recognition and also the high-level interdepartmental working group within government. I'd like to talk to the secretary about this. I'd like to thank the secretary for allowing 3 paragraphs on this issue in the paper today. First of all, the marriage ordinance was vetoed by the majority at second reading here in the Council. The first question is, after that, did you review the amendment bill with the Security Bureau, whether it would go to LegCo again? If not, are you going to wait for further proposals from the Interdepartmental Working Group on Gender Recognition before you take it forward? And then in para 67, you more or less told us about the progress of the working group, but you only told us about the number of meetings. Last year, we had a Bills Committee on the Marriage Amendment Bill, so there was a channel for us to communicate with the administration. Now, can you now also arrange for regular reports to Council here, the progress of this working group, so you can communicate with members? Can we have half-yearly meetings or at least yearly meetings? The thing is, what kind of mechanism do you want to use? Do you want to come here or to the security panel or the constitutional affairs panel? And number 3, also on para 67, it says the IWG will continue to consult widely in the course of its work it will issue one or more consultation papers. Is it that these one or more consultation papers will be issued in 2015-16? And you say to gauge what the overall consensus may be, if any, before finalizing its recommendations to the government. When you say if any, does it mean that you have reservation about coming to a consensus? Do you think it's very difficult? If you look at UK, they took 5 to 6 years to come up with the Sexual Recognition Act. I'm sure this will go beyond the present term of government. My proposal for the Secretary is, rather than arguing on 100% or full sex reassignment surgery, why don't we allow people of whatever sex to set up a partnership so that they have their rights and they can enjoy their rights without affecting the present marriage system? I have also asked the administration properly to set up such a partnership law, but I don't know who to talk to within government. Should it be HAB or CMAB or you? Secretary, thank you for those questions. I will give a brief answer to para 67 first. First of all, making regular reports of progress to this panel, I have an open mind about that. Before I decide what to do, I think I am duty-bound to talk to colleagues concerned. As Mr. Chen was asking, should we come back here or to other panels? I think I need to take a look. If I remember correctly, last time the IWG in fact went to the Constitutional Affairs panel. No. You went to the Marriage Amendment Bills Committee. Oh, thank you for that correction. So in principle, I have an open mind. I'm absolutely open about coming back to LegCo. So let me go back and take a look. And then secondly, also para 67, one or more consultation papers, and that we will conduct wide or broad consultation. I can report to members that when we had IWG meetings, we in fact have asked doctors, psychologists, and people who have undergone surgery, albeit not 100% surgery. We have already consulted these people informally at the working group. We have separated our work into two main parts. One, what kind of administrative or legal mechanism to recognize somebody who has undergone 100% or less surgery, and what kind of recognition we want to give this person. I can tell members that we have already done quite a lot on this first part, and to a certain extent we have got a blueprint of an initial consultation paper. Just last week we had a meeting, and we still would like to improve upon the report. Sorry, other members are in the queue. Let's see whether we can have a second round. Ms. Emily Lau. Thank you, Chairman. I'd like to ask the Secretary about the rule of law. Secretary, in the paper today and also on other occasions, you said that the rule of law is important in that we should defend our rights and freedom. But Secretary, you have just talked about abiding by the law. At the opening of the legal year, I was there as well, and you said that the rule of law is really about abiding by the law, and you were heavily criticized by the sector that you were not, you were being partial, because the rule of law includes defending justice. If something is unjust, we should speak up. At present, we have the constitutional reform, and the PLC has changed the entire setup from a 3-step process. It is now a 5-step process, and you dare not speak up. Many legal professionals are saying that elections can be based on international standards, that electors should have a free choice. But then the DOJ has remained silent. How can we defend the rule of law? How can you just ask people to abide by the law, and if you do not abide by the law, you are hurting the rule of law? And people talk about civil disobedience. Civil disobedience is basically different from breaking the law. But whether deliberately or not, you're just saying that people are breaking the law and you don't explain further. Some people say that civil disobedience actually is and can exemplify the rule of law, and you don't say anything about it. And you still say that the Public Prosecution Division will again meet the public and then also deepen the young people's understanding about the justice system. Are you going to brainwash them? If you want to meet them, you have to tell them how the rule of law is seen to be exercised. You should not just tell people that once you break the law, you are not upholding the rule of law. Please explain yourself. Secretary. Thank you, Ms. Lau, for the question. Actually, in the concept of rule of law, I have to clarify. Number one, I never said that the rule of law is just about abiding by the law, whether it is at the opening of the legal year or the opening of the legal year last year. I said very clearly that the rule of law includes different aspects. At the opening of this legal year, I put the emphasis on abiding by the law for a special reason, against a special background. And you know, because there was the Occupy movement, in the context as an official, especially as the S4J, I absolutely have the responsibility to emphasize that point. But on other occasions, I also said that while I emphasize that point, I have no intention to belittle the other aspects of the rule of law. Just now, Ms. Emily Lau said I was criticized. Yes, I'm aware of that, but I'm sorry, I cannot agree with those criticism or remarks. I think they are partial, and they have quoted me out of context, and I never meant that. But do you agree that you should defend justice if there is injustice, like changing the constitutional reform process from 3 steps to 5 steps? Why did you not say anything about that? I will come to that. At the DOJ, defending the rule of law, of course, includes defending justice. But Ms. Emily Lau, maybe you are not talking about justice within the legal framework. Under our constitutional framework, the NPC decision on the 31st of August was reached against our constitutional setup. From a legal point of view, unless there is a higher legal authority which can overthrow that decision, if this is not done as a barrister, as an S4J, from the legal point of view, we still have to abide by that decision. Ms. Lau, you also said that the Public Prosecution Division will be holding activities, whether we are going to brainwash our young people.
I think you have elevated to a completely different area. These activities have been organized by the Prosecution Division in the past, and they aim to enhance awareness and understanding by the public on our legal system and the work of the Prosecution Division. I don't think there is any element of brainwashing in these activities, and neither is there such intention. Please let the Secretary finish. And it's not easy to brainwash someone. That's like impossible. Civil disobedience is not a defense. This is still a controversial idea, a philosophical idea that is still discussed in among the academics. I'm sure, Ms. Lau, you are very clear about that. Next, Mr. Paul Tse. Recently, our judicial system has been undermined seriously. No matter how you see it, you will agree that it has harmed our legal system. It's only a matter of degree. our judicial system is our cornerstone. Is something that we are proud of. Is the best in our neighboring in this area. Of course, a rule of law and rule by law are very easily distinguished. However, in Chinese, it may be very difficult to differentiate between the two. Well, it's reported by the press that some people refuse bail, and some people are asked to go to the police station to be arrested. If it's not clarified, then the public may think that calling someone to make an arrangement to get that person arrested, or refusing bail by the person who was granted bail are both a right thing to do. Well, you represent the Department of Justice. Well, there are some sayings that are quite exaggerated, that you've been knocked out by the potential arrestees' action of refusing bail refusing to accept bail themselves. Would you do more? Would you openly and clearly explain the situation to dispel any possible misunderstandings? And in relation to your prosecution policy, I understand that this involves a lot of people. And of course, normally the DOJ will not comment on individual cases, but this is an exceptional circumstance involving a lot of people. Some of them are respected by the public. They are lawmakers, they are scholars. If there is no explanation given, and if you just say that you will act in accordance with the law, there will be misunderstanding. With so many cases, I think it's impossible to enforce the law accordingly, because there are just so many people involved. Some of them are just onlookers. So how wide is your net? You only target those who plan it, or anyone who participated in it. You have to tackle this. You have to take into account resources of the DOJ or the police. Are they able to handle so many prosecution cases? And no matter what you do, you will upset someone. Given the special circumstance, would you consider amnesty if a person is just an onlooker? Or for someone who just participated without doing anything aggravating, would you not prosecute them? Would you take that into consideration and not strictly enforce the law and prosecute them? Well, in short, amnesty is not a suitable approach, and it's not in line with public interest. We will take into consideration public interest and facts of the case in each and every case. If appropriate, at the right time, we will explain fully our prosecution policy in relation to this movement. Yes, I agree that this is a special circumstance and it warrants clarification and explanation. And in relation to refusal of bail and whether we should explain, I agree. If necessary, we will explain to the public. But sometimes we face a certain constraints, and it's not appropriate for us to say too much. Next, Mr. Albert Ho. Well, if If you're going to grant amnesty, don't consider me at all. Please don't. A lot of us take this very seriously. Even if is breaking the in relation to breaking the law, we want to express our strong objection to what is going on. So hear us clearly. Some of us don't want amnesty. At least myself. I don't want amnesty. There is another hot topic. That is whether Article 18 of the Basic Law can be used to turn the national security legislation of mainland China to become our legislation. This is proposed by a delegate of the NPCSC. Those close to the legal sector said that it may not be the case that it is not appropriate, but nothing is said whether it is related to Article 18. So, is it the case that that Article 18 can be used so arbitrarily? Please give us a clear explanation. Article 18 states very clearly the scope of laws that can be introduced into Hong Kong. And they have to be in relation to maybe national laws, foreign policy, national security. And if really that is the case, it should be Article 23, and it's for Hong Kong to decide whether to enact. Someone said that through Article 18, the mainland national security law can be introduced to Hong Kong. Can you explain clearly whether it is in contravention of Article 18? I've actually answered this question. If you don't mind me repeating myself, I'd like to elaborate. If you refer to Article 18, there are two parts. One is laws that are to be added to Annex 3. They are in relation to a number of areas, and it says very clearly that is to be done by enactment in Hong Kong. And it also says that if the NPCSC declare a state of war, or by reason of turmoil within the Hong Kong SAR, which endangers national unity or security and is beyond the control of the government of the region, decides that the region is in a state of emergency, the CPG may issue an order applying the relevant national laws in the region. In relation to this second part, well, there is no state of emergency. As I said on Saturday in reply to media inquiries, in relation to Article 18, if national laws are to be applied to Hong Kong, certain conditions will have to be met. This part and the former part, that is those laws and listed in Annex 3 are confined to those relating to defense and foreign affairs, as well as other matters outside the limits of the autonomy of the region. And Article 23 is in relation to the region enacting laws on its own to prohibit any act of treason, assassination, sedition, subversion against the CPG, or theft of state secrets. It says, enact laws on its own. And well, I think it's for Hong Kong to act if it decides to do so, and if anything along this line is to be applied, it should be along the lines of Article 23. And so at this stage, we don't have a timetable for enacting Article 23. Mr. Leung Kwok Hong, I think the Secretary said it. Someone has to declare a state of emergency before it can be applied. I think this guy has gone out of his mind. But even if when a state of emergency is to be announced, is it to be declared by the guy or C.Y. Leung? Of course not. And it is. It also says under Article 18 that is by reason of turmoil, which endangers national unity or security. I don't know why we are discussing this. The scope is very clear. Secretary, who is to make a declaration? Can the guy, the NPCSC delegate, declare it one day he wakes up and decides to do so? If you refer to Article 18, the fourth paragraph, is the NPCSC's decision to make such a declaration. Can I add that C.Y. Leung, in his first time's response to this, he made it clear that the Hong Kong SARG does not have this at this stage have such plans. This chief executive never said that the conditions stated in Article 18 have been met. Well, but according to him, he said that there are external forces, and he also mentioned about what some students said in paragraph 10 of the policy address. Well, and the condition hasn't been met yet because he has not reported to the NPCSC. Perhaps he might think that the NPCSC meeting time will be the right time. Paragraph 10 of the policy address contains information that he may report to the NPCSC. Well, you don't come to us very often, but I don't want to take this chance to scold you. Well, Article 18, the last paragraph, said that otherwise, these conditions are met. The national laws are not to be applied. Well, as I said, the CE did not say that he has the intention to ask the CPG to do so.
So we have to be fair to him. He never said so. And secondly, anyone can make a comment about Article 18. Whether you agree with him or not, that's another matter. As to whether we should speculate too much, well, at least for me, I have no information to make me think that I should speculate further. So the standpoint of the SARG is that if state of war or turmoil has not been declared by the PRC, and in other words, legally speaking, there will be no way to introduce the public order law into Hong Kong. Is that right? So Mr. Chow Pak is saying something that is meaningless, right? Because he is an NPC delegate. Thank you for your explanation. I say again, if the NPCSC does not act according to Para 4 of Article 18, in other words, that kind of emergency, then there is absolutely no way for the public order law of the PRC to be introduced into Hong Kong. Is that right? If you can't answer this question, you should be sacked. You have $300,000 a salary every month. You have to say something. People are very worried. You have to say something. People are actually thinking about emigrating because of that remark. People who have already emigrated are seeking a third report, a passport. Secretary, I think I have already answered that question twice. once on Saturday and once just now. In other words, only under special circumstances or conditions can we invoke Article 18, and those conditions have not arisen. Okay, Mr. Chen Kam-lam. Mr. Leung Kwok-hong is very interested about Article 18 and the declaration of emergency. And under Article 45, it is said that when we want to have constitutional reform, we have to act in accordance with Article 45. When we talk about the basic law and the rule of law, we have to be consistent. We should not be selective in talking about the rule of law. Some people break the law and then they talk about freedom and human rights. When they ask the government to abide by the law, they say something else. My feeling is, Secretary, when you seek to defend the rule of law of Hong Kong, you must be fair and just and open. All these years, Hong Kong has become an important player in the international arena. It is because we have always exemplified the rule of law. Some people only look at their own or a minority's political aspirations and they break the law deliberately, but they call that human rights. They call it freedom. That is wrong. Especially in the recent Occupy movement, the main propositions are against the basic law. Those are against the NPC-SC decision on the 31st of August. If people break the law and they call it part of the rule of law, then I would say the vast majority of Hong Kong people will not stand by it. Some of our colleagues here were arrested recently and they were released unconditionally, it was said. But I believe under the present system, these people are still being under arrest, but they have not been prosecuted, so they still enjoy freedom. Therefore, in the Council today, some people who have been arrested should declare interest when they speak about this. Chairman, Mr. Albert Ho has been very frank. He is not asking for special treatment when he faces the law. I commend him for that attitude. I hope when the court handles these cases, I hope the court will act according to the law and not look at the special identities of certain people, or because there are many people who have been arrested, that the court would allow some pardon to be given. Especially this Occupy movement, it went on for 79 days. It affected Hong Kong people very much, and it caused a lot of loss to Hong Kong's economy. And also, it has dealt a blow to the spirit of the rule of law. Therefore, if there is any pardon or so-called amnesty, I think Hong Kong people will not agree. This will be a bad precedent. Many people have already said there will be this march on the 1st of February. There will again, or maybe people who will deliberately occupy some areas. And this may well go on, and this may become a regular kind of exercise. Even if you, the S4J, will work to your level best to safeguard the rule of law of Hong Kong, but if this should happen again, it will be very difficult to control the situation. And there will be a big blow to Hong Kong's law and order. So I hope, Mr. Yun, you will be fair and just, and you should also act according to the law and abide by the law when you tackle these cases. I think Hong Kong people have high expectations of you about this. Okay, can you finish? As I said, as for J, I hope you will work very hard to defend the rule of law. Okay, that's a comment. Now it's my time. Basically, I like to express a view for the consideration of the S4J. First of all, with regard to paras 64 to 67 of the paper, I hope when the Interdepartmental Working Group on Gender Recognition goes about its work, you should respect Hong Kong's culture and our core values, our moral values, that they are different from those of the UK. And in fact, we have received a lot of views. I hope when you go about your work, you should respect and safeguard the freedom of religion, and please do not only take UK as reference. I hope I can have another discussion with you on this later on. Secondly, many members have mentioned the Occupy movement and the rule of law. I think the public are quite lost now as to what is the rule of law, because people have seen different interpretations of the rule of law recently. Well, this is a basic issue. It has never been controversial, but this time around, many members of the public are now quite lost about this. I would have to say that I cannot agree with Professor Benny Tai and his definition of the rule of law, and that is, after breaking the law, you turn yourself in, and then that is the rule of law. I think that is a crooked argument. Hong Kong hails the rule of law. We are proud of a community with the rule of law. Hong Kong's laws and systems are such that court orders after a fair trial is taken should be followed and abided by. But of course, that is not what the rule of law is all about. The rule of law also includes fair and just procedures, that people will not be deprived justice because of a lack of means. Everybody should be or have the right to a fair trial, etc. And also the presumption of innocence. In other words, someone is presumed innocent before proven guilty. Also, we should respect the supremacy of the law from our heart, and the law should enjoy supremacy over arguments and controversies. In Hong Kong, people say if there is a dispute, let's go to the court. But in the Occupy movement, there is a rift done to society. And how are you going to tackle this big number of people who have broken the law? I think those who have learned or studied law, we should go to the blindfolded lady of justice. If there is not enough evidence, whether or not the motive is correct or not, we should still let him go free. But then if there is strong evidence, then we should apply the same standards. On the issue of pardon or amnesty, I have thought about mediation, etc. But then I have heard quite strong voices of opposition. People said the government and the court should act fairly. But this is a very special situation in Hong Kong. If there is pardon, there will still be a lot of voices of opposition. So I would say, let us strictly adhere to the principles of the common law. Even if we want to hold someone guilty, it must be proven beyond reasonable doubt. But then you really have a big number of people who have broken the law. I was very sad at the beginning of the Occupy movement because I know people are going to paralyze the police stations and also the courts. This will take time. And I'm also worried about your manpower resources. But still, We cannot just say, let's pardon some people. If indeed some people have taken part, but there is not strong evidence, and if the evidence is not proven beyond reasonable doubt, then they should be let free. Well, you can explain this to society. Some people asked me, why is it that you call people up, you say they will be arrested, but then if they refuse bail, they are released unconditionally? I think the public is already confused. You have the responsibility to explain this process to the public so the public can still have confidence in Hong Kong's legal system. I don't need any reply from you. I know time is tight. Now, in the first round, we still have Elizabeth Quat, and I will still allow a second round. I will extend this item by 15 minutes. Ms. Elizabeth Quat will be in the first round. In the second round, I have 5 members. I give 2 minutes to each member in the second round. Ms. Elizabeth Quat. Thank you. I'd like to ask the S4J. This policy address is titled Uphold the Rule of Law, Seize the Opportunities, Make the Right Choices, and Uphold the Rule of Law comes first. We have faced an Occupy movement that went on for 79 days, and then many members of the public are asking me, why is it that you have not been arresting people and prosecuting people? Is it because you don't have enough people in the government, that you are incapable in tackling such a vast number of people who are lawbreakers? Do you need more manpower? So when can you complete your prosecution work? And as the chairman was asking, and the secretary did not have time to answer, so I'll put the question to the S4J. Why do you want to make an appointment with people over the phone to tell them so they will be arrested at the police station? And then why is it that they can refuse bail and then that they are released unconditionally? Can you now explain to the public what is happening? Because not everybody in Hong Kong understands the judicial process. Thank you, Chairman and Ms. Quat, for the questions. I will start, and then the DPP can explain the situation. At the present stage, the police are still doing investigation. As you have heard on the news, the Commissioner for Police has said that he hopes to complete all investigation within 3 months and submit the information to the DOJ for making prosecution decisions.
So at this stage, the bail arrangements and refusals, and I think it's a wrong term that is used. Perhaps I will defer to the DPP. Well, when it comes to the refusal to accept bails, well, there are different rights of people who are under investigation. During the investigation, well, within 48 hours, the suspect will have to be taken to the court. If at that time the evidence with the police does not reach the threshold, the police should not charge him just to take him to court. So bail is given to the suspect. So for fairness, the police should not charge that person without sufficient evidence. And the police do not have the power to force someone to accept bail. If the suspect refuses to accept bail, the police cannot impose bail on him. So there is no charge, there is no prosecution, and the suspect is released unconditionally. But the police reserve the right to continue investigation and initiate a prosecution if there is sufficient evidence. So It's something to do with rights of the suspects and powers of the police and the court and the DOJ. Can the police force bail onto a suspect without sufficient evidence? Well, this is not the time for discussion, but if you turn it into something that the police have done wrong, if you paint the police in a poor light, I think it is that is not the case. It's something to do with procedure. So, do the police have sufficient manpower to deal with the numerous prosecution cases? Secretary, of course, when it comes to manpower, the more the merrier. But at this stage, we have a sufficient manpower to deal with all the cases. I have to thank the DPP and the colleagues in the prosecution divisions. They have worked very hard without complaining. The police will plan to finish all the investigations within 3 months. So how long will it take for prosecutions to take place? Secretary, it's difficult for us to tell without certain information. But for justice and also for our prosecution work, we will deal with the prosecution cases as soon as possible and make announcements accordingly. 2 rounds, 2 minutes each. First, Mr. Dennis Kwok. I would like to ask about class action. Paragraph 61. I remember in the past year or two, I asked the Secretary about progress. Regrettably, there is very little in the paper about this. It only said there are 8 meetings. So, what is the progress? And it was previously mentioned that the LRC members should be full time. Do you have any plans to do so? I will answer questions in relation to the LRC, and when it comes to class action, I will defer to my colleague. We're still studying the direction. Given resources consideration, we don't have a clear way ahead first. I will defer to Mr. Poon, Solicitor General, in relation to class action. In 2012, the LRC released a report on class action. In October 2012, we set up a cross-sector working group to look into how to implement the recommendations in the report. We will make proposals to the administration. We have had 8 meetings so far. There are lots of complicated legal issues. Say, for example, if we focus on consumers, how do we define consumers, and what types of action are we talking about? When will you have a conclusion? Last year I asked, and I was told that it would be last year. I would like to know when. It's rather complex, and it involves a lot of legal issues and legal procedures. Hopefully we will be able to release the consultation the paper as soon as possible. Mr. Ray Chan, I would like to give the Secretary time to answer the rest of my questions. That is, the marriage ordinance was voted down. Will it be introduced to the legislature again? And if gender recognition is as such an arduous task, then would they consider non-gender specific civil union? If this is to be discussed, which government department is to be responsible? Would you allow me to digress a little bit? In relation to the working group, there are actually two parts, two different discussions. And if we can expedite consultation, then the public may get a better understanding. And in relation to civil union law, this is outside the terms of the working group. Perhaps in the second part, that is, gender recognition after gender reassignment, and what rights and obligations one has, legal advice will be given. But I must say that this is not under their purview. We are still discussing with the Security Bureau about our work in the coming year. I would move a motion about civil union. So I would like to know which department or bureau is going to answer my question. I did not raise my hand, Ms. Emily Lau. I did not raise my hand. Mr. Porter. I know that, there is a need to enforce the law, to caution people who have broken the law. I mentioned about this amnesty because sometimes the law is not fully enforced. Say, for example, plea bargaining. There is a selection of the offences to proceed. We're talking about hundreds of thousands of people participating. So no matter what you do, there will be someone who's left out, and the person who's left out will mock the government for allowing him to go scot-free. And we're talking about opportunity cost. If you spend so much resources to enforce the law, then you won't have enough resources to enforce the law on other areas. And so maybe the police will ignore these cases, or even ask the complainants to not make a report. And on top of that, there is filibustering. They delay the procedure in the court as well. But sometimes if you represent yourself, you are allowed a lot of leeway. And as a result, the proceedings is lengthened. It will, if someone wants paralyze the legal system. I'm not saying that the law should not be enforced, but you should choose the lesser of two evils. Instead of doing it in a half-baked way, maybe you should take a different approach to save yourself from being criticized. Secretary, when it comes to pardon, well, we have actually considered this. But there are complicated legal issues that may not be resolved. There are also other considerations. Mr. Leung Kwok Hong. Well, what's the difference between me and Mr. Chen Kam-lam? I think that the basic law should be drafted by Hong Kong people and should be amended to achieve universal suffrage. And it's for Hong Kong people to decide what is universal suffrage, not for the NPCSC to do that. And you cannot blow my buff. Have you heard that the Constitution is given to one place by someone else? Is the mainland Constitution given to China by someone else? Well, there is a chance that the administration has breached the Constitution. I think we're talking about two completely different levels when you talk about breaking the law and breaking Constitution. Well, I will say what I want to say in court. You should ask Rimsky-Yuen to prosecute me. And it's because he heard you, he's listened to you, that there is double jeopardy First, there is obstruction of public officer, and there is also criminal contempt of court, and you exert pressure. Don't think that after Li Taoyuan has said that there is more to come, that you can act. You should know shame. And he's listened to you, and I was taken. But there was insufficient evidence. I wanted to defend myself, but I couldn't. But there was insufficient evidence. That's why they've lost cost. And there's also double jeopardy. If you don't know about it, don't say anything. Well, if you have sufficient evidence, then you won't let that person to go away on bail. That will be strict prosecution. You think that Li Taoyuan is mighty and powerful? I know that there is more to come. Mr. Chen Kam-lam. Well, the difference between me and long hair is that he has got long hair and I've got short. I'm a law-abiding citizen when he's not. Basic law was formulated over 3 years or so. There are representatives from Hong Kong and from the mainland. They work together. After extensive and long-term consultation, formulated the basic law. So it is not a one-sided effort. It's not drafted by the mainland for implementation in Hong Kong. That is very clear. That's our history. And what Mr. Leung said doesn't stand here because it's not true. Well, I think a lot of people are watching what you are going to do. And you may be criticized for letting someone go scot-free. If you have sufficient evidence, you should prosecute. And you should follow the legal procedure to show the public that you are impartial in dealing with this large-scale illegal occupation. If there is insufficient evidence, of course you will have to follow the common law. Without sufficient evidence, you cannot proceed with prosecution. That we respect. Secretary, you would like to say something? No, thank you. It's now 6:15. I thank the Secretary, the Bureau Secretary for taking part in this discussion. Next, we have item number 4. Provision of screens for complainants in sexual offense cases during court proceedings.
Okay, you can indicate your intention to speak, but I like to tell you that I'm going to exercise my discretion, and we will extend the meeting to 6:45. The relevant paper is CB bracket 4367 bracket 05.
司法機關提供嘅有關文件。
A paper provided by the DOJ. On the 27th of May, we wrote to the Judiciary proposing that upon application by the prosecution, the complainants in sexual cases should be provided with screens in court. The Judiciary has provided the paper to state their views on the issue. I'd like to ask Mr. Ng Hon, Deputy Judiciary Administrator, to introduce the paper, and then we'll ask the Hong Kong Bar Association to speak. Mr. Ng, please. Thank you, Madam Chair. Thank you for inviting us and the DOJ for speaking on the issue. The matter has been raised for some time, and the paper states clearly the issue of provision of screens for complainants in sexual offense cases. At present, we do according to the common law. There is no statute law to provide for this. Every time when considering whether a screen should be provided, it is up to judicial discretion. Ms. Elizabeth Quart asked a question. After detailed investigation, and as we stated in the paper, after we have got this facility, how many applications were received and how many were granted and refused, the figures are in para 6 of the paper. I will not go into the details here. The relevant factors for consideration are in the Hong Kong Bill of Rights, and that is in Article 14, that in such cases these should be heard in a fair and public hearing. And also Article 39 of the Basic Law also states that if these rights are to be limited, these should be strictly prescribed by law. And the paper goes on to talk about the role of the judge. When the judge exercises his discretion, he has to balance a few things. There is the prosecution, the defendant, and also the complainant. And the paper also cited a case of last year, which was also the subject of application for a screen. We have given the detailed explanation here. So, in general, I like to say that the judiciary made a few proposals or options. First of all, whether this should become automatic every time an application is made. Now, if we were to do this, we have to have the law to provide for this. If not, there will be disproportionality. And under option B, we like to try to do something with the practice directions. And that is, when there are such cases, during pre-trial review, we can provide this as a matter of standing procedure to require consideration to be given as to whether the complainant has requested a screen and whether the prosecution considers it appropriate to make such an application. This is option B. Option C, it's whether we should set some guidelines. But then this will unavoidably affect the unfettered exercise of judicial discretion. So we have reservation about this, and after looking into the details, we think option B might be preferable. As to the future and whether laws should be made, I'm afraid this cannot be decided alone by the judiciary. Maybe the community should discuss this first. The judiciary does not have an established stand on this. But under present circumstances, we think option B should be able to help strike a balance. Thank you very much, Mr. Ng. Now I'd like to invite Mr. Andrew Bruce to speak.
Thank you. It's a delight to be here and try to assist on this topic. The Bar has a multitude of concerns and interests in relation to this topic. I don't accept that the discretion that judges have is unfettered. And I say that for the following reasons. First of all, it has long been the practice to afford some protection to victims as a case develops. not just in sexual offences cases, not just in sexual offences cases involving females, but in a multitude of cases. Blackmail is a good example where protections are made with respect to witnesses, and there has been a long tradition of that. We have had in statute for something of the order of 20 years protections under Part 3A of the Criminal Procedure Ordinance in relation to television, live television link, but protection of vulnerable witnesses in all sorts of ways. And they have become, certainly in my experience, almost routine. The recent decision of a judge of the High Court ordering a screen recognised in many respects some of this growing tradition. So although I respect the observations just made about an unfettered discretion, I frankly don't buy that. There is already a growing movement in this direction. The common law in just about every jurisdiction that I know of, Canada, New Zealand are good examples, Australia, already have a tradition of respect and protection. Some call it a triangulation of interests between the parties. But we cannot get away from rights to a fair trial and a public trial. But all of that said, the recent decision said this doesn't have anything to do with a fair trial, because the accused will get that anyway. It's more about public trials. And already, as I say, we have seen in the last particularly 20 years changes in this regard. For my part, and I think the bar's part, a practice direction would be the best way to go, simply because it gives a multitude of flexibility. Not every case calls for a screen. A lot of cases which don't have screens probably should have screens. But a practice direction which forces the parties, and perhaps particularly the prosecution, to actually think about this issue at an early stage would be a big step forward. I hope that's helpful.
Okay, thank you, Mr. Andrew Bruce. 去到我哋嗰個委員發問。
Now it's time for members to ask questions. I'd like to remind members that we have tabled today a letter from the Association Concerning Sexual Violence Against Women. I hope members will read it, and for reference, it has been tabled at the meeting today. 4 members would like to speak. I will allow 4 minutes for each member. Ms. Emily Lau. Thank you, Chairman. Chairman, we have been discussing this for many years. Last year, we went to the judiciary and we raised this with the judges. And on the 9th of March, we are going again. I hope this will be placed on the agenda so the Chief Judge knows that we are going to bring it up again. And from this letter from the Association Concerning Sexual Violence Against Women, I think we know their views very well. Earlier on, Rain Lily came to us and we said that we would give them a hand. Of course, we understand that we need to listen to all parties. As stated in the letter, they say that the letters in para 6, the figures in para 6 are not accurate because they said at least 5 cases have been refused. Now you say no cases have been refused at the High Court and the District Court. And now you say option B is the best. But you did not say whether there is a timetable or whether there will be consultation, and we are just waiting for something to happen. Is that right? I think women victims would like to see something done. Everybody wants an open and fair trial, but they think what they are proposing should not be a detriment. So can you not be more concrete with your proposals? And I'd like to ask you why your figures are wrong in para 6. Mr. Ng. Chairman, about the figures, we have checked the figures many times. But if they have the information, please let them forward the information for us to cross-check again. As for option B, well, it is not going to be a legislative exercise. We are just going to change the practice directions. We will do it as quickly as possible. Chairman. Yes, Ms. Lau. Well, I think the concerned group would like to see laws made. Is it that you object to that because you need to do consultation first? Or is it that you are now not going to do anything? Mr. Ng? Well, making legislation is not within the jurisdiction of the judiciary. But are you proposing that? Well, we are saying if you want to do that, you need to have some laws. It is not that we are supporting it or objecting to it. Chairman, in fact, they just want protection. If you preserve the status quo and you can still give them protection, I think the women groups would agree. But then they think the present situation is not satisfactory, so they are crying out loud. And they must be watching this meeting now, and they would be disappointed. They would think that they have spoken to the wall, and the figures are incorrect. Okay, women groups, you can see what the judiciary is asking you to do. You cannot even be correct with the figures. How can I expect you to improve the policy? This is ridiculous. Just now the bar has said so, and they are talking about the practice directions. I don't know what is happening. Let us be more practical, Chairman. The groups asked us to have a public hearing because the women groups would like to find a solution. They are very worried. Some of them do not want to come forward because they are so afraid. How can we give exemplification to the rule of law? Mr. Ng, can you go back and check the figures again? Yes, we will do that. Yes, we'll certainly do that. When we go to the judiciary on the 9th of March, we will bring that up again. Let me just add, with regard to the practice directions, we have strengthened it. Every time at the pre-trial review, this will be brought up before the judge. So it will be more comprehensive than what we have now. Good. Dennis Kwok. Thank you, Chairman.
Well, just like what Ms. Emily Lau said, we've had this discussion a long time ago. But now I see some specific proposals from the administration. As Mr. Bruce said, change to the practice direction. It will result in the matter being dealt with earlier, and that will be a step forward. But if the PD is to be changed, when can I have a timetable? And in paragraph 21, you said that in the PTR, the judge would be asked to inquire as to whether the complainant has requested a screen and whether the prosecution considers it appropriate to make an application. Can you elaborate on A and B? Because the two is not enough. Because the complainant will have to be explained. Will have to be explained that if you think that you need the protection of a screen, you have to voice it to the prosecution, so the prosecution will ask the judge. And then the complainant will be asked whether there is a need, and then the judge will have to ask complainant whether you think there is a need or whether you think there is no such need. So the PD should state very clearly what the judge should consider. What we don't want to see is that the prosecution decides There is no such need without asking the complainant at the PTR. And while changing the PD, you should also consider changing the law. Yes, the letter may need a lot more time. And I agree that you should change the PD first so that the victims are given the protection as soon as possible. Option A and option B are not mutually exclusive. You should proceed with option B first while thinking about how to proceed with option A. I don't know why the department is not asked to, the Bureau is not asked to attend, because we'll ask them whether they would consider proceeding with option B while at the same time working on option A. And we would like to know about the stance of the Bureau. I believe, Mr. Ng and Ms. Chen, do you have anything to add? I don't have anything to add. And I agree that what we can do now is to explain as soon as possible to the victim about the situation. And in relation to this issue, we've been liaising with NGOs. Say, for example, difficulties, merits, disadvantage, or whether they know what to do to ask for it. Rain Lily approached us on their initiative, and we've had a meeting. We asked them about any proposals, whether they think it's a good idea or not. And we made improvements in the report, and we sent them a letter. Asking what Mr. Kwok has covered. That is, apart from a screen, what other protection do they think is good enough? And how will the victims know that there is such a protection available? And how the information should be passed on to them? And I think we would like to hear your views, but we will have to let members ask questions first. Ms. Elizabeth Kwok. As the two members said, we have we've been discussing it for quite some time. Well, I didn't realize it's so difficult to shield the victim from harm the second time by providing a screen. We're only stating what we stated a year ago. Well, now we've heard that there is option B. The current arrangement will be changed. That itself is good. If it is properly communicated to victims and if the application procedure is easy, I'm sure that bodies like Rain Lily will not complain again. And there's no need for them to make that demand known again. I believe that most members here will support legislative amendment to offer such protection. But those who sit here told us that then they will reflect our views to the administration, but there is no one here from the Bureau. So our meeting is actually fruitless. Can we invite the administration to talk to us as soon as possible about how to take forward option A, that is, to legislate so that provision of a screen will be automatic. And I would like to know more about the improvement of the procedure. How different is it going to be? I've heard a lot about the technical points. Can you elaborate on this so that people from Rain Lily and victims that are still considering whether to report their case will feel assured that they will be given protection. Mr. Ng. We can improve the PD to make it a standing arrangement. In the PTR, the question of whether the complainant is to testify behind a screen will be brought up for the consideration of the judge. The complainant will be asked whether she needs a screen and whether the prosecution will make such a request. Detailed questions will be asked. For the consideration of the court. Under the existing arrangement, this question may not be brought up in a PTR. And of course, after the change, it will be an improvement. If a complainant makes a request, a decision, will there be further discussion at the PTR whether the request is granted or not? But if there is a need to make an application, it will be made by the prosecution and then for the judge to decide whether to accept or not. And it's similar to the exercise of discretion under the existing arrangement. Why do we have to go through such a long argument before a decision is made to give victims protection? I would like to hear more about it. Next, Mr. Porter. I understanding that is to choose the lesser of the two evils. And I've heard Mr. Bruce about the stance of the Bar Association. Victims in a sexual offense case, it feels embarrassed. It's just like when someone has got sexually transmitted disease. I think there is a consideration related to culture. And sometimes people from a different culture, say for example from the West, may not fully understand what people think in a Chinese culture. But I agree with Mr. Kwok that we should take a step forward by improving it at the PTR. The person in charge will make this a checklist, or maybe it should be turned into an opt-in, opt-out choice. The paper says that the discretion of the judge may be affected, but that is not my consideration. Just like when a bail should be granted. Of course, there are some guidance in authorities, but it doesn't mean that the court's exercise of discretion is affected. If you make this a checklist, this is just to remind the judge about what to do. It will also enhance understanding by the public as to what factors are considered by the judge, and as to whether this will guarantee this will affect the fairness of the trial, whether it's non-compliance of the basic law. Well, if the defendant is obstructed from seeing the lawyer, that is a completely different matter. If it's only a screen shielding the victim away from the defendant, say for example, that is different. I think the screen we're talking about here is that to shield the victim from people from the public who are just interested in the case or find the case interesting. Let me go back to my previous point that Chinese culture, the taboos like sex, that itself deter people, victims, from reporting a case. And it seems that the number of applications and the number of refusals are both low. Well, are these figures formal applications? Or are they related to cases that have been, or are there a lot more cases when the victims are advised to not use a screen, or the request has been turned down before it reaches the court, thereby resulting in a low number of refusal and a low number of cases? We collect the figures from the courts. An application will have to be made first, but we don't have the figure before it reaches the court. Maybe you should dig up the information. And let me make an observation. Paragraph 25. You say that having considered the above, the judiciary considers that option B should be adopted. Option A should be referred to the administration for further examination, while option C should be rejected. Well, you have briefly set out what option B is about, and you've explained to members about the difference. Can you spell out the details about the improvement in information paper? There are people who don't have legal training, and they're listening to this meeting, and they would like to get more information to help them make a decision. We will meet the Chief Justice on the 9th of March, and you've heard that last year we have expressed this specific request to Jeffrey Ma last year. There is a lot to do to follow up. Please reflect this to the CJ. And in relation to a public hearing, I think there's been 2 public hearings. If you're not happy, and if you ask the Bureau to attend, we will have to invite the Security Bureau to join us. Of course, we have a representative from the Bar Association. Mr. Bruce is very familiar with this issue. This is a long and winding road, but we have to work very hard to get a good result. Let's make some arrangements, and on the 9th of March, we will meet the CJ again.
Today, it's really for members to express their views on the paper and the choice of option B. But we think the paper is not detailed enough. I think you should go back and work harder. And as members were saying, you might have overlooked certain figures because some people might have been refused at an early stage. And that is why the community groups are still unhappy. Okay, that will be our follow-up work. We'll see how many deputations would like to come to see us, and at the same time, the Security Bureau should be invited to come. Okay, so thank you very much for coming. Yes? The DOJ. Just now, Ms. Agnes Chan, Assistant Director of Public Prosecutions, you have heard us. I think maybe you can now respond briefly. Members would like to hear from you. On which aspect? To respond to our views expressed just now, members were saying that there should eventually be statute law. Can you reflect our views to the government? Well, our department has no particular preference. It really depends on the administration and the judiciary and what possibilities, what proposals they may have. We act as the prosecution. We just invoke the law to prosecute. If there is not a statute, we would use the common law. So we do not have an established stance on this. Well, I hope the administration will be better prepared next time. You cannot say you have no stance because we have already forwarded our views to you many times. We will invite the Security Bureau to come as well. I think this time around they are making a proposal. They also agree that the present system should be improved upon. Ms. Elizabeth Quat, please be very brief. Chairman, after the meeting, please clarify with the administration if a law has to be made, which bureau should be held responsible, or else they will be passing the buck around and eventually no one will be responsible. Okay, we will be liaising with the Security Bureau and also the DOJ. And if we have more concrete views, we can take it to the CJ on the 9th of March. The meeting is adjourned here. Thank you very much for coming. May I wish you a very happy Chinese New Year, a very prosperous year of the sheep.